Hello and welcome to SME TV. I'm your host Angela Vithoulkas, bringing you the latest in news and views for the SME community. There isn't really anything more heartbreaking for a business owner than being thrown out of their place of business by their landlord. Imagine turning up to see a padlock on your door. Unfortunately, this could be a common sight in the not too distant future. To join our SME TV community, just subscribe to our YouTube channel. We need your support, not just for us, but for all SMEs. And we encourage you to comment and share SME TV. Joining us today to discuss landlords, leases, and the issues around the mandatory Tenancies Code is Richard Mitry for Mitry Lawyers. Welcome, Richard.
Thanks, Angela.
Serious subject, very serious subject. Now, just before we get into the nitty-gritty of what's going on, the code came in April and it was meant to run alongside JobKeeper for the duration of COVID. Has that changed given that JobKeeper's been extended? What's going on?
Well, right now we don't know if it will change or not, like everything in relation to COVID.
So
and
we
the
don't
law,
know. We officially don't know.
No, we don't know. There's been no announcement about the extension of any moratorium in relation to the code or the way it's been applied around the states and territories. As it stands, that code or the effect of it will come to an end on the 24th of October.
That's what we're all assuming.
Yeah, that's right. Well, we can only assume what we know right now.
So they're avoiding addressing the elephant in the room.
Yeah, and it's a big elephant too.
It is. Now, I'm going to add a disclaimer, not that you gave it to me, but this is general information. It may not work for whatever situation you're in, and there are many small businesses out there who are struggling from this. That's what I'm getting all the phone calls about. They should get individual legal advice, and we'll cover that too, because one of the things we're saying, should you do it yourself? No. So they should get good legal advice, and they should be aware that they have the right to get good legal advice.
Absolutely.
So we don't know if it's going to continue past October. It came as a bit of a shock, I think, to a lot of landlords that this code was going to come into practice. And how is it meant to work? There's a code. It is and it isn't forced, but it's been legislated, so technically landlords have to abide by it, right?
That's right. Well, yes, most definitely. For any business that is entitled to JobKeeper, so therefore has a revenue of less than $50 million a year, and can show that they have had a downturn of 30% or more year on year, then a landlord who has a tenant that is eligible because of that has to comply with it. Some landlords simply don't think they do, so they do. This
is the issue. So how is it meant to work?
Yeah. In short, there are a set of very general principles that were mandated by the code. The code was then, the code itself is not law. It didn't come into effect when the code was handed down in March or thereabouts.
That's right.
This
year. March.
It was
April.
Yeah, well, the code was legislated in April, at the end of April. And in New South Wales, for example, came into effect on the 24th of April this year, for a period of 6 months.
Yes.
So what that meant was that any landlord who had an eligible tenant, because they're basically entitled to JobKeeper, had to consider those principles under the code, which in very broad terms, and they are very broad terms because there's a lot of flexibility built into negotiation in good faith, which is one of the requirements, is that if a tenant has had a percentage of turnover which exceeds 30%, then a landlord has to give at least a rent reduction
of the
proportionate
same
of the same amount, and at least 50% of that has to be waived forever and never recoverable, and the other 50% can be deferred, which means it's basically a loan that's repayable over up at least 2 years. So it has to be at least a 2-year repayment term for that deferred balance.
Now, on the surface, that sounds and looks great. A big assistance for those small business owners, particularly the portion that is waived, because it's not accumulating. There's some comfort there. It wasn't going to fix everything, but it was a little piece of comfort. Now, on the other side, because by the time we finish talking about this, I don't want to skew it all. For some landlords, that was an issue for them too. So there are smaller landlords who live off that income, that rent, and for them to have any leeway or give there, they would also be facing hardship. So there is the other side of that coin, and we acknowledge that.
Yeah, of course. They're small businesses in effect as well.
That's right. However, looking at it from the 90% that are the small businesses operating in a premises. This code came down. On the one hand, it looks and sounds good of assistance. On the other hand, we've got landlords who are doing nothing. They're not following any part of the code. So where's the section in the code that says if you don't behave, this is what happens?
Yeah, so
because there's no consequence, right?
well, there may be. So there are a lot of, I've heard the cases that I've heard about. So for example, I'm not so much as a lawyer dealing with the negotiations, right? Often the accountants for these businesses are dealing with the landlords directly to try and submit figures and get
and we will talk about the documents.
But if landlords don't cooperate, if they just blatantly ignore the request for rent assistance, they're in breach of now legislation. So if they then try and, right now, obviously they can't for that 6-month period terminate any leases. They're not allowed to kick anybody out for non-payment of rent. They can if there are breaches of other terms of the lease, but for non-payment of rent.
And you've been clear on that to make sure you comply with the rest of the lease?
Yeah, you have to comply with the rest of the lease. So this only relates to rent and the payment conditions of the lease. It doesn't relate to all. So if you go and just rip your fit out and redo your fit out and you don't have approval from the landlord, they can terminate the lease for that reason.
So we need to be mindful about all the other rules in the lease that you would follow as a matter of due course doing business.
That's right. So, but subject to that, if the landlord simply just disregards or doesn't negotiate in good faith, technically they're in breach of the code. Or the legislation that brought into effect the code. What that then means is that a tenant can force them to mediation. So retail tenants can do that anyway under the Retail Leases Act, but all commercial tenants can do so under the legislated.
Because commercial leases were different,
Exactly, so they couldn't do that previously. And then if there's a mediation and that's conducted in good faith, then a landlord generally at that point, there'll be a certificate issued by the Small Business Commissioner, and the landlord can in fact then terminate the lease if there's no compliance. If that doesn't otherwise achieve anything and the tenant otherwise believes the landlord hasn't followed the principles of the code, they can take the landlord to the tribunal. So even if a landlord, for example, terminates the lease after a mediation or even tries to before, a tenant can say, no, you haven't complied with your legal obligations. You're not allowed to re-enter our premises and terminate our lease. In other words, getting what's called an injunction, a restraining order stopping them doing that, because you haven't complied with your obligations. That's quite a technical area of law, which relates to, amongst other things, a thing called relief against forfeiture, basically saying the courts can, or the tribunal in certain circumstances, can stop a landlord taking possession of a premises from a tenant.
So it's a process to go through, but there is some safety net there for a situation where, because I know of situations, I have people calling me that say, we've done everything we can and the landlord will not respond or negotiate in any way.
And that's happening a lot. I'm hearing that too.
It is happening a lot, Richard.
And rent is
worried about this.
Well, there are a lot of, I reckon the majority, in fact, of small businesses who aren't paying rent right now, or trying to, but can't. At the end of October, they could have 6 months accumulated rent. And chances are, if they can't pay it month by month, they can't pay the whole 6 months in one whack on the other side of it. So
they could find their bank guarantee being cashed in.
Well, that's possible as well. Although right now, of course, the bank guarantee
until
can't be
October
cashed
24.
in.
But then if there's no indication from the government of extending the code, then it's all up for grabs, isn't it?
Well,
this is the stress that's happening.
Yeah, of course. And there's a lot of uncertainty. And there are a lot of landlords who have very good procedures in place already to deal with this. And I have to give credit where it's due. There are
some doing a terrific job.
In fact, I think probably the majority of the bigger landlords are. They are dealing with their tenants. They're doing the right thing. They're going through the procedures. They're negotiating properly. But there are those others who are simply either ignoring it or just dragging things out, thinking at the end they'll just do exactly what you said.
And often some of these landlords that I'm getting feedback on aren't even based in Australia. They're overseas. Right. So there's a communication breakdown in who's managing the property and who's actually making any of those decisions. And I worry about those waters being muddied. One of the concerns and issues that you brought up with me was the quality of the documents. So this is a big part of the negotiation. So the tenant might have a right to have some of the rent waived or deferred in any way, but they still have to prove something. So is that where some of the hiccup is happening in what documents the business owner is putting forward for the landlord?
Yeah, that's right. So so do you mean the documents to prove their turnover?
Correct.
Yeah, sorry. So that's right. So the tenants, every small business, by their nature are different. They keep different accounting records. They have different standards of record keeping. Their accountants may or may not have material that is relevant. So it's fundamentally important to do what you can to comply with the requests of a landlord, as long as they're reasonable requests. And they do demonstrate, in fact, that you are entitled to JobKeeper. So I've had a lot of clients now come to me and say, my landlord's not engaging with me. They're saying I'm not complying with what I need to, and they're refusing to give me any rent relief. Then I see what they've been given, and sometimes it's an email saying my income in March last year was X and now it's Y, and they're not actually giving them anything. So it's a two-way street in that regard. Really, businesses should be lodging their BASs, so they should have them readily available. There should be financials, because you have to lodge your financials by May the following year. Correct. As a company, or earlier if you're an individual, sole trader. So they should have these things readily available. Management reports, if there's a MILB or something similar that can be given, those sorts of things, basically the same things you'd need to give to the ATO in order to get JobKeeper in the first place.
Or a loan.
That's right.
Or to just do your own due diligence within your own business, which you should be knowing what your cash flow is doing.
Oh, you have an obligation to.
we have those issues. So let's just say that the main winners out of this, I think, are the accountants, who, great deal of respect, they are completely run off their feet now and overworked. But every part of this process of COVID seems to involve an accountant because they need to have the paperwork ready, and lodging JobKeeper, etc., is almost always going to fall down to the accountant as well. Yeah. So, this is, I think, an ideal time for everybody, landlord and small business, or the tenant, to really either understand where you're both coming from. For a lot of good change, the Retail Leases Act had an opportunity a little while ago to factor in lots of different things, but it didn't, unfortunately. Maybe this is an opportunity to review some legislation. But are you hearing of any new COVID clauses coming into new leases?
Yeah, I've.
What are people doing to avoid an issue later?
Yeah, so there are a lot of, believe it or not, there are companies signing new leases right now, and it's amazing. Like, I've had probably, I reckon, maybe 15 new leases signed since COVID hit for tenants, for retail tenants predominantly. And they all, because it's basically, I think, a tenant's market right now if you are signing a new lease, they're insisting on clauses that aren't strictly, they say they're COVID clauses, but of course they don't just apply to COVID-19. No. Because people are now a lot more worried, just like after SARS, all the insurers put in clauses in their insurance policies saying we won't cover if there's a pandemic. Right now, obviously, there's an issue about that.
They're going, yay.
So it's very similar, but this time the other way around. The tenants are coming and negotiating with landlords and saying, we insist that, for example, if there's a government restriction, we don't want to wait for legislation to come in, or some code or something that doesn't necessarily apply to our situation. We want, for example, to not pay any rent for every day we're prevented from going to the premises. And if our income drops, we want our rent to drop proportionally while we can access the premises.
And I think that's going to be a great clause to be tested, because it will be tested. You might agree to sign it, and then it can be contentious further down the track. Yeah. That would be interesting, but very mindful for everyone, because when the government said lockdown, that's not anyone's fault. But who pays for that?
Yeah, well, everyone's paying for it.
And everyone pays
government.
For it.
and that's
us for a long time to come.
Yeah, that's right. Another thing that's a very creative solution that I saw one of my clients negotiating on a few of their leases, because they basically renewed a whole bunch of leases at the same time, was turnover rent. So COVID clauses are one thing, but turnover rent.
We've all been pushing for that for a long time.
Yeah, it seems to be coming into effect.
It's a fair way of doing it.
You
make money, you pay more money.
Yep, and that's.
Your turnover drops, you don't pay the money.
And landlords are starting to, certainly the institutional landlords are starting to appreciate that.
And so they should. Get good legal advice. Get very good legal advice. Thank you. To everyone in YouTube land, press the button so you subscribe. Why? So you get more of the latest news and views from SME TV. To the Piedmont Studio, thank you for making us look and sound absolutely perfect, I think. To the SMEA Association for your support. Without you, this wouldn't happen. To everybody out there who has tips, tricks, comments, stories, or other legal challenges, you can email me directly, news@smea.org.au, and of course, we're across all the socials. And a big shout out to Mitry Lawyers for being a fantastic new sponsor of SME TV. We'll see you all next time. Thank you, Richard.
Thanks.